Okay, let's just kick off. Welcome to this morning's Naptons webinar on shareholder disputes. My name is Keith Melling. I'm the head of Naptons corporate team, and my role is to advise business owners on, amongst other things, corporate matters, including entering into shareholder agreements and articles of association. I'm joined today by my colleague John Whittingslow, and I'll just hand over so John can do a short introduction.
Hello everyone. I'm John Whittingslow and I head up the corporate and commercial litigation team here in Naptons. Litigation, it covers a broad spectrum of disputes, but thankfully for everyone on this webinar, I specialise in shareholder disputes, so hopefully I'll be able to plot your way through what happens if things go wrong. Thanks,
John. So we thought today's session would be useful, particularly in the current climate and in light of COVID-19, where businesses and running a business becomes more challenging for the owners and creates disagreements over strategy, contribution and reward. Disagreements often can't be resolved, which means there is a parting of the ways, which will usually always involve a corporate lawyer, but it's often the case that John, as a litigator, will get involved from a contentious aspect as well. So just before we start, to go through a quick format of today's session, Wayne, if you could just knock the slide on. So the running order for today, short introduction, we'll talk about how disputes arise, give a few examples of what we see in our experience leads to shareholder disputes, which may resonate with some of the viewers. Talk a little around the lawyer's role in handling disputes, and also the possible remedies and outcomes available. We've got a short case study we can present to put that into a bit more context. We'll then move on to talking around the alternative, which is a negotiated settlement and what needs to be considered in that situation, and round off with some top tips. There will be a chance to ask questions. If you tap the Q&A box on your screen, it should allow you to be able to tap out a question. You don't need to be anonymous because we won't be naming any names. We've already had a few questions sent in advance, so we'll try our best to get through all of the questions, both the ones we've had already and the ones we received during the course of the session. The session is expected to last for about an hour in total. It's timely that John has a conference with counsel on a shareholder dispute at 12:15 today, so we'll look to finish by midday at the latest. And please do feel free to get in touch after the call. We'll email our contact details to all attendees so you can arrange a time to pick up and ask further questions specific to your case, which we'll try and help out with. So to begin, let's just turn first of all to how shareholder disputes can arise. And sometimes it's a one-off event that's created the fallout, and sometimes it's an accumulation of grievances that's just built up over the years. And the reason the lawyers become involved, the reason the clients come to us is because this is the final straw. Over recent times, we've seen disagreements for all sorts of reasons, but by way of example, the most common, I think, is where there's a lack of commitment from one of the shareholders. And a good example here is where you've got a sleeping investor, for instance, who's injected funds at the start of the enterprise, but has then just taken the back seat and allowed the remaining shareholder or shareholders to run the business. After a few years, the business starts to become successful, and as it increases in value, the management shareholders get fairly disillusioned with the stake retained by the sleeping investor. They're arguing they're not making any commitments anymore. They're sent management accounts. They never ask any questions. They're invited to attend board meetings or observe board meetings, and they just don't really make any contribution or even bother turning up. They don't put any further funding in the business. And the management's perception is that the sleeping investor by this stage is just taking dividends and doesn't really support any further investment or growth in the business. And I think that's probably a more acute situation in the current circumstances, given the economic climate and given the current challenges to take on further CBILS loans, furloughing staff, dealing with challenges around customers and suppliers, where the pressure is really on the management to try and resolve those issues. And obviously, there's always two sides to any argument. And from the sleeping shareholder's perspective, the investor perspective, he'll just say, well, you know, I leave the management to run the business. I don't cause a fuss. I don't want to get involved. I'm happy for them to run the business as they see fit. I put my money in, and that's all I wanted from this relationship. So that's probably one of the most common causes where we've just reached that breaking point. On the flip side, there's often a situation arises where there's underperformance from the management shareholders' perspective. So there's a lack of commitment as far as the sleeping investor is concerned. That can range from not having the right skills to grow the business and take it to its next level, through to actual misconduct, refusing to turn up for work in the morning, or alleged breach of duty where, for instance, the shareholder director has got other interests in other businesses which may well conflict with his interests and duties to the company. We often see disagreements arise over business direction. So often, even if there's no fault involved on the part of either side, there's just a difference in vision or maybe in operational styles. And you can really choose any subject you like as to the reason why this might come about. It could range from not wanting to expand overseas trading, not wanting to go online, a decision to outsource an element of the business, the recruitment or replacement of a key member of staff, sharing the equity, offering share options to key people, making acquisitions, capital expenditure, the list goes on. And any of those could just either singularly or over a period of time just create that disconnect between the shareholders. There's often disagreement over the rewards a shareholder takes out of the business, and that's more likely to be a complaint as much from the management as from the sleeping investor. If there's an increase to a salary or a bonus arrangement for management shareholders, that's going to impact on dividends and profits available to pay those dividends. We've actually seen a case, John and I worked in a case where there was an executive shareholder, significant shareholder in the business, who was actually off work on long-term illness, but didn't accept that the remaining shareholders who were running the business were entitled to take any more value out for their efforts. You can see disagreements over exit strategy. Do we ever exit? Some shareholders really want to be there for the long term, never to exit on the basis of a long-term employment opportunity or revenue stream, and they feel exposed if they were to be sold to a trade buyer or private equity because they feel they really won't be able to cut it in that different environment. There could be next generation issues. If you've got an example of, say, a family business or a brother and sister startup with 50% shareholdings apiece, the next generation comes through, both shareholders look to retire. The next generation, one has a son maybe who's gone to university and maybe gone to work for a law firm. Now he wants to come back into the business. The daughter, on the other side of the fence, from the other shareholder, has been in the business since leaving school, now the managing director. How do they reconcile their contribution to the business? Is the son who's come out of the law firm worth 50% of the shareholding that he holds? Are you a shareholder because of what you do or because of who you are? And that can actually lead to quite significant disagreement and disruption between the shareholders. Finally, there's just the general issue around the personality clash. You don't have to be friends to be in business. In fact, sometimes it's better if you aren't, but a lack of an effective working relationship means that decisions can often be made for the wrong reasons. So that's a brief overview. I don't know, John, have you got any others that you'd add at that stage?
I think only on a granular level, Keith. It's the classic SME where one of the director shareholders actually forgets that they are in a corporate entity and treat themselves and behave themselves as if they're a sole trader and forget about their director duties and responsibilities to the company as an individual entity and the other shareholders. And that is, certainly in the smaller companies, that's a classic cause for disagreement. Yeah.
So there's plenty of examples there, and some of those may resonate with some people on the call. So what's our role, and how can we help, and what do we do? Well, our role first and foremost is to advise you on your rights to either take action to deal with the situation, or you may be on the other side of the fence and defending a claim that's been made against you. Principally, our job is to advise you in light of understanding the result you want to achieve. You may want a day in court, but that will come at a cost, both financially and emotionally. So it's in our interest to act in your best interest and understand what you want to try and achieve. And I'll just hand over to John briefly here, because he can put that more into context from a litigator's angle.
Yeah, thanks, Keith. I think that most clients will get to my door once they've exhausted every avenue of trying to resolve whatever the issue is, and that often involves Keith and his corporate team. But at some stage, if there is no resolution, no deal to be done, then they're going to need the input of myself and my litigation team. And I think probably to give the audience a feel for what happens, I'm just going to give you examples of standard questions, regular questions that clients ask me when they come to see me. I think before I start, just a bit of levity. I don't know if the audience can see it, but this is the Bible on shareholder disputes. But to make it more difficult for me, they printed it upside down. So that just gives you some idea of how complicated the law is in this area. The first question that I discussed with the client is, what have they been doing to try and resolve the issues that they've got? In other words, what do they want? Because what they want will really govern which legal route we go down, and we're going to deal later on in the webinar in a little bit more detail of what the options are. But just broadly, your three main legal routes when you're in a shareholder dispute that's not capable of being resolved without involvement of the courts is an unfair prejudice petition, a just and equitable winding up petition, or what's known as a derivative action. Now, if those of you don't know, never heard of those phrases before, don't worry. As I say, later on we'll touch in a little bit more detail about what they are. But which route you take is very much governed by what you want. Do you want out of the business? Do you want to sell your shares? Do you want to buy the other person's shares? Do you simply want to regulate the other person's behaviour so that they behave properly within the company? Do you want them to put back in something that they have taken out? Or have you got to the stage now where you think this is the end of the road, the business needs to finish and close down? So we need to understand what you want and then discuss what your options are. The second question is always, once we've decided which route we're going to go down is, well, am I going to win? Will I be successful? And that's a much harder question to answer for a variety of reasons, but the main one is that litigation in general, not just shareholder disputes, is governed by statute, what the laws of the land say. It's governed by what's known as common law, or rather more commonly known as judicial law, the judicial decisions that courts have made in cases. And then the process itself is covered by what's known as the civil procedure rules. So that's the framework within which we have to work. But unfortunately, for every rule or every law, some judge somewhere will have created an exception, which is fact specific on each case. So it makes it very difficult at the outset to tell a client whether they're going to win or not. But what we will be able to do, and what any good legal team will be able to do, is look at the facts that you present to the lawyer at the time and give you a feel for which way it could go and give you a percentage of where it could go. But remember, in litigation, nothing's certain. It's only certain when the judge gives his judgment at the end of the case. The third common question is, well, how long is it going to take? On average, if a shareholder dispute runs all the way through to a trial, and statistics tell us that 90% don't, 90% of shareholder disputes that are started in court settle before the trial. But if it goes through to a trial, you're looking at an average of about 18 months before you get a decision. So you've got to factor that into your decision-making process of what am I going to do? And then the fourth thing is how much is it going to cost me? And that's a massive one for obvious reasons. Shareholder disputes are playing in the big league because you're in the High Court, and therefore costs are incredibly expensive. Most litigation lawyers will tell you, well, don't panic because the loser pays the winner's costs. And that, in principle, is correct. But as I've already said, for every principle, there's an exception. But that is the general rule. But a winner will never get all the costs back. They'll only get a proportion. So even if you take a case to court, you can't settle it, it goes to trial and you win, there will be a chunk of cost that you do not get back. And you've got to try and understand with your lawyer early on some idea of what that could be, and that again will affect your decision-making process. And then once you've talked through that, if you decide that, well, I'm going to have another go at negotiating and it doesn't work, or if you decide, well, negotiation won't work, let's crack on, then you present the paperwork to the court and the process starts to run. And I think, Keith, that probably is it in a nutshell. It's a lot more expansive than that, but for the purpose of the webinar, I think that's a pretty decent guide to the process and what clients need to discuss.
No, I think that's great, John. I think that's really, really helpful as a snapshot to give people a feel for, well, costs and timescales certainly, and how quickly they can expect to get, a feel for where things are likely to go. I mean, when we get involved, we're most commonly asked to look at what I'd say are fault-based issues. So you can have situations where shareholders just have reached a disagreement and no one's at fault, but often something's happened where one of the shareholders has done something which has irked to the other shareholder, and the other shareholder has complained and said, look, this just isn't what we've agreed. It cuts across either a shareholder agreement or understanding we've had, or I think it's in breach of a duty or obligation that the shareholder director holds. So we thought it'd be useful to take an example and to put some colour on it, I guess, and some context, so that we can take the example and then John can just run through some thoughts around how those remedies he's touched upon might apply to give redress to, in this case, a minority shareholder. So taking the example, let's say we've got two shareholders, Donald and Boris. They're 75%, 25% shareholders in an aerospace engineering company. Donald's got 75%, and he's fully involved day to day. Boris holds 25%, and he's a sleeping investor, so he puts some cash in at the start, but doesn't really play any active role. However, both are board directors, as well as Tom and Dick, who are non-shareholder employees. They are directors, not shareholders, but they are very close to Donald. And let's just say it comes to light that Donald's placed, first of all, two issues. Donald's placed a lucrative contract for the supply of IT support services to the company from another company in which he holds a majority stake. And the contract was for a long term at extremely high rates, and there was really no evidence of any sort of procurement or tendering process to award the contract. Donald's or the board directors decided to award the contract to that particular company. The second issue is that Donald has increased executive bonuses payable to himself, Tom, and Dick. The company, however, has recently had to furlough a number of staff and apply for a CBILS loan, which is repayable in 5 years' time. The profits for the year are likely to be slightly reduced, but not significantly. But nonetheless, they've increased the exec bonuses and also decided that no dividends are going to be paid, despite being paid in previous years. And with that scene setting, I'll now hand over to John to explain how Boris might decide to seek redress against Donald, if at all.
Thanks, Keith. It takes me back 30 years to university, this, but thanks for that. Just so everybody knows, Keith did give me a bit of warning before, and so I'm not completely off the cuff here. Poor old Boris has quite clearly been subject to behaviour or conduct from Donald that is inappropriate and would open up a number of options for Boris to deal with Donald. Obviously, a lot would depend, as I've mentioned already, what does Boris actually want. But let's just park that to one side and look at the three main areas that Boris could deal with Donald, or the way in which Boris could deal with Donald. The first one is the unfair prejudice petition, and that primarily would be the route that we would go down if Boris wanted now to say, well, I'll tell you what, I've had enough, Donald. You're really taking the proverbial and I'm off. And he would then be asking the court to make what's called a compulsory share purchase order, whereby Donald has to buy Boris's shares at a value that will be ascertained by an independently appointed valuer. An unfair prejudice petition, people often think of the word petition and it's an insolvency situation. It isn't. It's just an equitable remedy, equitable meaning you're in the court of fair play. So that means that both parties have to behave properly. So even if Boris was was found by the courts to have been the victim of unfair behaviour, if he'd been a bit naughty himself, then the courts might decide not to give Boris the remedy that he wanted. So that's just something to bear in mind, that if you are the victim of unfair prejudice behaviour, you've still got to play with a straight bat. Two wrongs don't make a right. But to succeed, Boris would have to establish that Donald's behaviour was unfair and prejudicial to him. And a lot of lawyers do get themselves confused and think it's one and the same, but it is unfair and prejudicial. And looking at what Donald has done, he would, on the face of it, have breached a variety of director duties. He's got himself into a conflict of interest by piling work to a company that he's involved with. Ostensibly, he's not declared his interest to the company, to the board, with regards to the other company. And maybe, just maybe, he's got the company that Boris is a shareholder in paying over the odds as well. So he's got a conflict of interest, and there would be a good case to say that he's not acting to promote the interests of the company that Boris is part of, and therefore, as I say, on the surface, he's been guilty of unfair and prejudicial behaviour, and Boris could petition the court and ask for a compulsory share purchase order. If Boris thinks, well, do you know what, the business is all right, we're doing okay, this is the first time that Donald's been a bit of a trump, then he might decide that he simply wants the court to regulate Donald's behaviour. Now that would be done probably primarily through what's called a derivative action. A derivative action is really designed, and it's built up over the years, to help a minority shareholder take action on behalf of the company. And that's because actually Donald's conduct has offended the company as a legal entity, as well as Boris as an individual shareholder. But a company will not take action against a director shareholder when that person is the majority shareholder. Why would he agree to let the company sue him? He wouldn't. So what the courts have developed is this concept of a derivative action, whereby the minority shareholder can go to court and say to the judge, this is what's happened, would you please let me make the company deal with Donald and regulate his behaviour? And that would be a derivative action. The results for that, or the remedy for that, are quite wide ranging, but if Donald has stripped out cash, for example, if he's paid £100,000 more on the contract to his company than the Boris company would have paid to another contractor, then Boris could say to the court that 100 grand's got to come back into the company, and the court would allow Boris to pursue that action on behalf of the company. A little quick point on derivative actions: they are notoriously slow and expensive, and one of the reasons for that is the first thing Boris would have to do is get the court's permission to do it in the first place, and he has a number of hurdles to get over. And just boiling it down to one key thing, the courts would want to make sure that what Boris wants to do is in the interest of the company and not merely to promote his own interests. And if the court's satisfied with that, they would give Boris permission to launch the derivative action. If Boris has decided actually he's completely had enough of Donald and that this business isn't going to go anywhere, then he could look to try and petition the court for a just and equitable winding up. And basically that is the two main grounds for that these days are that there's been complete deadlock in management. That might not be the case here, because obviously with Donald being the majority shareholder, he can take things forward, and Boris might have some difficulty persuading the court there's complete deadlock. But what he could fall back on is a complete lack of confidence in the management, and his presentation to the court would be, well, look what Donald's done. He's got this company on the side, he's overquoted for a job that should have gone to that company over there at a much lower price. He didn't tell anybody he had interest in this company, and he's fleecing our company to feather his own nest over there. And that would be good evidence of commercial mismanagement, which would allow the court to wind up the company on a just and equitable winding up petition. So those are the main areas that Boris could attack Donald on. If there is a shareholder agreement in place, which quite often in SMEs, Keith and I don't see those, and that's a top tip that I think Keith will touch upon later. But if there is one in place and Donald's actions have breached that, then Boris might have the potential to launch a personal action against Donald directly for breach of the contract, the agreement. That really is the plotted history of it, but I think Keith, probably that would be the main areas that Boris could have a go at good old Donald across the pond if he wanted to.
That's great, John. Thanks. That's really helpful. As I mentioned, there are some circumstances where there is no fault or failure on the part of any shareholder. It's just an agreement over the direction of the business or a personality clash. And this is a case that's ripe for a buyout, but if the parties can't reach an agreement, then I think that's a situation where you're probably looking at the winding up order, particularly in a 50-50 JV scenario where neither party's got control over the other. So that's where the likely remedy, where there's no fault, but there is a deadlock, is the winding up process. So given it's likely to be a costly exercise to engage in litigation, and more importantly, put the decision in the hands of the third party, i.e. the judge. As John said, it's not surprising that over 90% of shareholder disputes that begin to be litigated are actually resolved before the parties enter a courtroom. And if you actually take account of all the shareholder disputes that don't even get proceedings issued, the percentage is likely to be even higher. Our role is often to help the client avoid a costly trial, and provided the parties are properly advised, a negotiated settlement is often a win-win position and an alternative to litigation. However, ultimately, once shareholders have fallen out and the relationship's irretrievable, neither party wants to be in business with the other. So that negotiated settlement either means a wind-up, but if the company's wound up, its assets are sold off, then there's likely to be a loss of value, unlikely to be any goodwill received, and no guarantee that the assets, if either shareholder fancies buying the assets for his own purpose going forward, they may well find themselves outbid by a third party purchaser. So the alternative is a buyout on a negotiated basis. And this is really where the non-contentious corporate department at Napthans would tend to pick up the baton to try and help the parties reach a deal. What are the key features of a negotiated settlement? Well, I've picked out 4 or 5 key items. I think the first is, fundamentally, quite importantly, decide who buys who. Usually, one party will have the greater drive to move the business forward. And it'll become apparent that there's one party who's happy to sort of make the commitment to take on the funding to buy out his co-shareholder. And the other party probably less inclined to stay in the business, particularly if a sleeping investor, and more inclined to be the seller in any buyout situation. The key question to ask in any negotiated settlement is obviously how much. What is the value being paid for the shares? So let's assume it's a share purchase, which is the most common route. It starts out really agreeing a value for the shares, and that's likely to require some help from an experienced accountant. Now, you do find people quite glibly say, look, it just depends upon, it's what a buyer wants to pay and it's what a seller wants to accept. But that negotiation has to have some basis in reality, otherwise the parties just aren't going to get anywhere. And that calculation, that valuation is normally driven by starting at looking at maintainable earnings and profits and applying a multiple to those maintainable earnings. And what I mean by that is taking historic earnings, maybe even weighting the more recent ones against the older ones, maybe even giving a weighting for existing forecast profits, and adjusting for non-recurring items like one-off items of litigation, for instance, that have impacted the profitability of the company. Add on the cash, take off the debt, and that, in very, very broad terms, gets you to a number. It can sometimes be, rather than a profit multiple, a net asset value, but that's usually limited to property investment businesses where there's more of a kind of a balance sheet value and a valuation based upon the properties as opposed to a living, breathing, trading entity. There's also the question of a discount for minority interest, which needs to be taken into account. Acting for a seller, you'd argue you wouldn't accept any sort of discount on the basis it should simply be a pro-ratering of the valuation based upon the percentage of the shareholding being held. That's a particular feature where it's what's called a quasi-partnership. Effectively, it's a relatively small number of shareholders who are both involved in the management and running of the business as well as the ownership of the business. Much like a partnership, they just have chosen to become incorporated through a body corporate, through a company. And in those situations, a court is more likely to say there should be no discount on for a minority interest. And that's certainly where a seller would start his negotiation. Obviously, it's not necessarily an easy process, agreeing common ground. And so it's important for the parties to bear in mind alternative solutions to reaching an agreement on valuation. That can include an agreement to pay an earn-out. In other words, you value the business partly based upon current value, but with an agreement to pay more if the company continues to perform profitably in the future, and calculate the purchase price based upon that level of profit. And another tool can sometimes be something known as the anti-embarrassment clause. Very briefly, what that involves is the buyer agreeing that if the buyer, after the buyout, sells the business onto a third party for a premium, then he will agree to share that premium with the seller, provided the subsequent sale occurs within a certain period of time. And the amount which the buyer agrees to pay onto the seller can often diminish based upon whether that sale is within the first 12 months, the second 12 months, and so on the basis that the seller's less embarrassed the longer away the second sale is from his buyout. It's really important the parties take tax advice. Whilst the tax tail shouldn't wag the commercial dog, it's really important to make it as tax efficient as possible for the parties. So we'd really encourage people to take specialist tax advice. The most common, just to give people a feel, the most common structure for an exit, in my experience, is an own share purchase by the company, provided it's got available profits on its balance sheet to cover the price, which has to be paid in full on completion. The buyback of shares by the company has the benefit of allowing cash to be paid directly by the company, rather than having to, if you like, the company pay corporation tax on its profits and then pay the cash up to its shareholders. They pay tax on the receipt and then they pay the exiting shareholder. So a company-owned purchase is often seen as a preferred way forward. Sometimes that's not possible because either the profits aren't available for the company, or maybe it can't afford to pay for the full amount on completion, which is a requirement of the Companies Act. In that case, you may look at a new co-structure where the purchasing shareholder creates a new company to acquire its own shares and the shares of the exiting shareholder, and that can then structure the payment on a deferred basis. As an alternative to that, you can look at a reduction of share capital. We're also seeing, in the context of splitting shareholders apart as part of a negotiated settlement, demergers as a tax efficient way of splitting either assets or the different elements of a business, so that if the shareholders go one way and one wants to take some assets and the other shareholder wants to take others, particularly in property investment splitting arrangements, then the demerger can work well from a tax perspective, particularly as regards stamp duty, land tax, and corporation tax. I mentioned earlier on funding, so it's obviously important to consider the impact on the business of the business having to borrow funds from the bank to fund the buyout. It's not necessarily the case it's going to have the excess cash available above and beyond working capital to simply pay out to the exiting shareholder in all one go. So consider what bank funding is made available, particularly in light of COVID. For that reason, in our experience, many deals which don't form part of buybacks of own shares with everything being paid on completion will involve some form of deferred consideration. So the buyer agrees to pay back the purchase price for the shares over a period of time. And that gives knock-on questions for the seller around whether it gets paid interest and what sort of security it receives for those deferred payments, given it will be usually quite a significant creditor of the company. Other terms just to consider within the context of a negotiated settlement would also include making sure that for the benefit of the buyer and the company, the exiting shareholder is waiving any outstanding claims, whether it's for unfair prejudice, whether it's for any allegation of breach of duty on the part of the directors, ensure that all outstanding loan accounts are paid up and settled. If they've received any salary or directors' fees, they're settled in full and final settlements as part of the deal. It's not uncommon where the exiting shareholder has been involved in the business for the buyer to say, look, I need some form of non-compete covenant from you to protect the goodwill of the business, particularly if the price that's been agreed does have a goodwill element to it. So Don't be surprised in those situations, or if you're a buyer, make sure you think about asking for non-compete provisions, agreements not to interfere with suppliers to the business, poach staff, or poach clients to the business. And also just make sure you pick up on any other threads that need to be tidied up, such as situations where the company may well own assets which are held by the exiting shareholder. Formalising lease arrangements, for instance, spring to mind. So that's a whistle-stop tour, I guess, of some of the issues that you need to think about when you're trying to reach a negotiated settlement. I'll just finish off this the main section of the webinar by just really illustrating what we think are some top tips for you to consider, both at the outset of the relationship and going forward. I think it's really important at the outset that each shareholder does some due diligence on his or her future business partners, looking at their CV, their experience, looking at their solvency, and maybe even asking for references and asking, well, finding out who others they've worked with and what they have to say about them. Have they invested in other businesses before? How has that gone? What sort of contribution have they made? The second tip, I think, is to agree on the vision for the business, both in the short and the long term. It's really important for the shareholders to be clear with each other about what's required from each of them to achieve their vision. And also be clear on the rewards for success, be clear on the dividends they expect to receive, the remuneration, the benefits, and how those may increase in time. And fundamentally, as John's already alluded to, it's really important you write down what you've agreed. So, for example, given our case study, it would have been ideal for Boris in that example to have a sensible set of restrictions and policies that would have applied to Donald and hopefully restricted Donald from, causing the company to enter into contracts with his own business or unilaterally increasing payments or bonuses to staff. And similar to the shareholder agreement, invest in a set of articles which clarify how decisions are made and how shares can be forced to be sold in certain circumstances. We often see issues where individual shareholders, minority shareholders who are involved in the business and have a shareholding, unfortunately the Articles of Association don't contain any provision which deals with what happens if they were to leave the business. So they may decide to resign from their office, leave employment and still remain a shareholder. And whilst it is possible with 75% approval to change the articles, with that comes some risk of a claim from the minority shareholder for unfair prejudice. They may well allege it was never expected that they had to be an employee to remain a shareholder, for example. So be clear around the legal documentation. And also, from experience again, we often see, and it sounds crazy that this happens, but there's often a real misunderstanding at the outset about whether financial contributions that are made to the company are actually loans or equity. So be careful allowing investors to loan monies on unwritten terms or to take security for loans. Make it clear as an understanding, is the company expected to repay this amount or isn't it? Because that's often a key feature of shareholder disputes where there's just no understanding between the parties as to whether this was meant to be locked into the business or repayable. And if it is made as a loan, just be careful if it's not written down, if you don't have terms to agree how it becomes repayable, because in the absence of anything in writing, the position will be it's simply repayable on demand. And if you do decide to take a loan from a shareholder and do decide to give security for that loan, bear in mind that puts them into a relatively strong position to call in the debt if it's not repaid and take control of the assets of the company, which can be a quicker way for them to get what they want rather than going through an unfair prejudice action. Otherwise, I suggest keep regular lines of communication open between shareholders so there are no surprises, and be transparent about what's going on in the business. Be transparent about connected party relationships in the example with Donald and Boris. But always be aware that whoever you get into business with, deep pockets matter. And particularly in the absence of a shareholder agreement, whoever's willing to spend the money on legal fees to put pressure on the individual, even a relatively innocent party, may find themselves in a position where they simply can't afford to litigate and being forced to settle. So do bear that in mind, and do bear that in mind in the context of how important a shareholder agreement will be. Those are, in fact, my top tips. John, have you got any others that you'd like to add?
Yeah, I think so, Keith. I think a lot of what you said there aims at prevention, and I think it's a well-used phrase, but it's true. Prevention is better than cure. But if you do find yourself in the situation of there is a dispute, then a couple of tips that I've got is, first of all, when you're discussing the dispute, trying to resolve anything with I'll now call them the opponent, because you're in a conflict situation. Please, please, please make sure that anything you say and write is covered by without prejudice. That simply means that if you put that on, if you mention that, if you put it on your correspondence and your emails, that will not be able to be used as evidence against you. If you don't, it might well be. So once you say, can I have a chat about things? Let's just talk without prejudice. You can say whatever you like, and the judge will never hear about it. And if the other side try and put it in, it will be thrown out. The other thing is early advice. And I guess that everyone's going to groan now and think, oh, yeah, of course the lawyers would say, come and see us straight away. But it's really true. I'm going to give you a real-time example of that, of the case that just settled yesterday that Keith and I were involved in. But early advice, first of all, will mean that you avoid going down a particular route that when you get to the lawyer says, what the hell have you done that for? And it's very important in cases of this nature. You'll recall I mentioned about equitable relief before, and making sure you come to court with what's called clean hands, so you behave properly. It's so easy to fall into the trap of not having behaved properly because you just don't know, and also because passions and emotions are running high. So get early advice so that you don't go down a route that your lawyer then can't pull you back from. In a case that's just been resolved, unfortunately our client had already done that, and by the time Keith and I got it, we just couldn't pull her back from the precipice he got himself into. And that was in connection with what purposes was his director's loan account. And our instructions were, well, it wasn't really a loan account, it wasn't repayable, it was more like alternative funded my remuneration package. Okay, bit of a stretch, but we can work with that if those are our instructions. However, the other side produced a massive correspondence saying, I know we followed out, I'll pay the DLA back. And we had a problem, and we really just couldn't get out of that. So he's had to settle on terms which are not as favourable as could have been. The other reason for early advice is you need to know whether the lawyers can get you what you want, because if they can't, then you might have to rethink. And it's much better to do that early on, before you've fallen into the real trap of a dispute with your co-shareholder. So again, get to your lawyers early and say, this is what I want. Is it legally achievable? Is it evidentially achievable? If not, then you need to think about plan B. If there is the situation where you are at the point of no return and you're going to have to look at litigation, another big tip is take the emotion out of your decision-making process. This is really hard to do if it's an SME and it's a family or close friends, and you've got a situation where you go into your litigation lawyers. Clearly the relationship has broken down. Obviously things will have been said and done. Take the emotion out of it. An emotionally taken decision is nearly always the wrong one. Passion is good. Passion is great, but take the emotion out of it and try and leave that at the door. Also, make sure, and this is something I always test with my clients, that you really have explored every alternative before going to the court. That's really important. And finally, if you do have to sue, then you need to commit. You need to commit your time, you need to commit your effort, and you will need to commit your funds. Because if you don't do that, then whilst I can't guarantee that you will win, I guarantee if you don't do that, you will lose. So just some tips there to think about if you find yourself getting into the situation of a shareholder fallout.
Thanks, John. It's 11:46. We've just got a few minutes to answer a few questions. I'll just go to a couple that were sent through in advance. The first question, in your experience, what is the most effective means of resolving a dispute between shareholders? Well, I think in my experience, that is effective communication, use of advisors. And John's already alluded to that. The situation where you can sit down with your client and maybe formulate some form of deal that can be put to the other side, which if the sense is there's just the relationship has broken down, it's a question of parting the waves, ways, then resolving the dispute is really around getting an offer agreed. And to John's point around the lack of emotion, getting an accountant involved at an earlier stage to structure a valuation exercise which works for both parties and is affordable for the buyer is an effective way of avoiding potential litigation. By taking the emotion out of it and keeping it just around the numbers and putting it in the advisor's hands means you're just going to get a professional approach, where I think one of the challenges, people tend to get really hung up on the nitty-gritty around not attending a board meeting or having said something in a certain way. And that sort of grievance, whilst it can really, be inflammatory for the parties, isn't particularly important to getting a deal done, but really doesn't really involve, really get much sympathy from the court, in my experience. One of the other questions: do a husband and wife?
Sorry to cut across. Can I just on that point about resolution, it might help the audience to perhaps get a bit of an understanding of why majority of cases don't get to trial.
Yeah.
The real reason is because the only guaranteed winners are the lawyers. And once you start court proceedings, the laws of our land now make it clear that you very early on in the case have to exchange what's called cost budgets, so that both sides know what the other's being quoted by their lawyer to get to trial, and then both can know, well, hang on a minute, if this doesn't go my way, I could be paying X plus these costs. And that's an amazing way of focusing your opponent's mind. And that's one of the reasons why sometimes you do want to issue proceedings a little bit earlier than you might do, so that you can let them know you're serious, and then let them know, well, this is what it's going to cost you, buddy, if we go all the way.
Thanks, John. Another great question: do a husband and wife need a shareholders agreement for a jointly owned company, or would the divorce process override the shareholder agreement? Well, it's an interesting question. I actually ran this past my family lawyer prior to the webinar, and our view is that a shareholder agreement in that context would operate as a form of, if they were already married, a post-nuptial agreement. And the point around post-nups is that the courts will have regard to them if they're comfortable that the parties are independently advised. So, for instance, if both shareholders came to, if a shareholder came to us and said, I want you to write a shareholder agreement that says that my wife and I both hold 50% of the shares apiece in the company, and if we get divorced, I get her shares for nothing. And let's say we prepared that shareholder agreement and the client went off and he and his wife signed it. The wife didn't take independent advice, she just signed the piece of paper because her husband asked to. Then that's a situation where the courts probably like to ignore the shareholder agreement because she hasn't really been independently advised and she's not really aware of what she's signing up to. As opposed to a husband and wife coming, or a husband coming to us and saying, my wife and I will like to sign a shareholder agreement, and the wife being separately advised, and us and her solicitor perhaps negotiating the terms of the agreement, it being clear that she had full awareness of what she was letting herself in for. The court is likely in that scenario to have regard to the shareholder agreement that although the shares are marital assets, the parties separately agreed as a post-nup exercise how they were going to divvy those shares up between them. So hopefully that answers that question. The next question: how enforceable are shareholder agreements? John, I'll hand that one over to you if that's okay.
Well, shareholder agreements are contractual documentation. So the starting point is they are enforceable. And if they are clear and they are unequivocal and your fellow shareholder has breached it, then you should be able to enforce it. That there is little doubt. But of course, don't forget all the list of exceptions where the judges in this country try and find reasons why the loser should be the winner and the winner should be the loser. But as a starting point, yeah, that's why we advise you get shareholder agreements done, so that you can point to something in black and white. This says that, you haven't done it, so therefore you've got a problem.
Thanks. Is it possible for a minority shareholder to stop the company from issuing new shares to new employees? Well, first of all, is there a shareholder agreement which gives the minority shareholder a protection? Shareholder agreements, one of the main purposes of them is to allow minority shareholders to veto certain matters involving the company, normally at a structural ownership level, so issuing new shares would fall into that category. So there may be something in a shareholder agreement that allows the minority to stop that from happening. Absent a shareholder agreement, then if you're, if you're a shareholder holding less than, say, 25% of the shares in the company, without going into all the legislation around preemption rights and authorities on directors to allot shares, the position would be that a 75% plus shareholder or shareholder group would be able to do that. However, given what we've said earlier in the webinar, the directors and the shareholders who were doing that would have to demonstrate they were doing it for a proper purpose, i.e. there was a legitimate reason to incentivize the staff in question. If this was merely a dilution exercise, then there's maybe an argument along the lines of an unfair prejudice action or a derivative action claim, which says, well, actually, you're not acting in the best interest of the company. You're just issuing shares to people who don't actually deserve them, not paying much for them, and it's just a way of basically diluting the minority. But absent that, then the courts usually allow the companies to be run in a way that really is really the way the directors consider the best way for the company to be run. They're the custodians of the company's assets, and provided they're not in breach of the directors' duties and exercising reasonable skill and care in performing their duties, then the courts are likely to support that approach. Another question: how do you remove a director or shareholder from a business when they don't want to leave? A great lawyer's response is that it depends. It depends what the shareholders agreement says. It depends what the articles of association provide for. But just as a rule of thumb, in terms of removal as a director or an employee, Companies Act legislation allows directors to be removed from office provided more than 50% of the shareholders vote in favour of that removal. Making a decision to fire an employee is largely based upon the board of directors taking that decision, depending upon the levels of authority given to individual directors. But let's assume it's another director. It would need the director to approve the removal of someone else as an employee. Removing a shareholder would normally involve something being written into the articles which ties that shareholder's shareholding to their participation in the business. So if you recall, a few minutes ago I mentioned having the wherewithal to remove employees, remove shareholders who used to be employees who cease to be employed. The key thing is to have a set of articles which allow that to happen, which basically allow the majority shareholder to say if someone decides to go and leave the office as an employee, then they also have to offer the shares up for sale at an agreed price. That can work against the minority, and is often something which is difficult for investors or management shareholders to get their heads around at the start of the venture. So if you ganged up on me, you could basically force me out. And the answer to that is, well, yes, because the rule is generally whatever's good for the majority is normally what's in the best interest of the company, subject to the examples around Donald and Boris, of course. So the position would normally be that a well-drafted set of articles will allow an employee who leaves to also be required to offer his shares up for sale. Without that, it's trickier and may involve having to amend the articles to include that provision, which then takes us back to potential arguments around unfair prejudice. Is there anything you'd want to add to that, John?
No, like you said, Keith, a lot of it would depend upon the situation and what's been going on. It really is as simple as that. And remember, of course, that if a director has got a service contract, there's not just your corporate legislation that affects it. There's also your employment legislation as well. But if they are doing something that's completely off the wall and wrong, then yeah, the law will help you deal with it.
There are ways and means of obviously buying out shareholders through negotiated deals. So even if there's nothing in your articles of association that gives you the right, it is a question of a commercial negotiation that is a possible exit as well. But there's kind of no ability to force someone to come to the table with that without the contractual writing either the shareholder agreement or the articles. Just looking at some of the questions that have been posed during the live session. The first question: if the dispute involves a minority shareholder, 10%, who is an active director, are there any options open for minor shareholders, or are they always in danger of being outvoted by a single majority shareholder of 90%? Without a shareholders agreement, yeah, the law would say that without a shareholders agreement, the minority is likely to always be in a position where the control will rest with the majority, will be able to, subject to duties as a director and the unfair prejudice point which John's taken us through, the majority will be able to call the shots. And the minority won't be able to do very much about that unless there are restrictions in a shareholder agreement, or unless the unfair prejudice petition could be successful or a derivative action claim could be brought, because the majority shareholder is acting in a way which is just simply detrimental to the company. The second question, if there is no shareholders agreement, how will this affect a minority shareholder if they choose to resign? Well, if there's no shareholders agreement, and by that let's also assume there's no detailed articles of association, then we're back to the point we discussed a few minutes ago around if a minority shareholder chooses to resign, then on the face of it they'll keep their shares. There are also ways and means of squeezing shareholders out through a statutory procedure, squeeze out procedure, almost like through a sort of takeover process and making an offer for the shares under the Companies Act. That's incredibly expensive, and I think that the advice would be, on balance, a better way forward, maybe if you've got sufficient voting rights to vote 75% of the shares, that the articles be amended on the basis that the justification for the change and saying that someone who's now a shareholder can be required to sell the shares is because that's for the benefit of the company as a whole, and because by removing a shareholder as a minority shareholder such that they aren't there anymore and buying them out at a fair value is actually giving the ability for the company to now incentivize other employees who maybe need those shares and can deliver future value for the company. The key thing, I think, when considering whether to amend articles to introduce any, if you like, squeeze out procedure or any ability to buy out shareholders and force that upon them with 75%, it largely turns upon case law, which says in turn that to do that would have to apply to all shareholders and would also have to apply a fair valuation to the purchase price for the shares. What's more likely to get into much more trouble is if the majority decides to include a provision that says, right, we can now force you to sell, and you sell for £1. Again, John, is there anything you'd add to that at all?
I think, again, just trying to look at some rule of thumb so that the audience have got something to take away. The acid test is what's being done in the benefit of the company? If it's not, then yes, the courts will step in if needs be, and will help you as a minority shareholder if you want to get out, and the majority are not letting you get out in a fair way. If they've done something that's unfairly prejudicial, then as Keith has said, yes, the courts will step in and make them buy you for fair value. So, which is very important. If they're trying to drive you out at undervalue, then that's one of the things that the courts will say, no, that's not going to happen. We will make sure you go at a fair value.
Thanks, John. So that's 12 o'clock on the dot. That's the end of today's webinar, which I hope has been useful for everyone listening in. Please do feel free to let us have any further questions, and we'll look to come back to you, discuss how we can help. Please do follow us on LinkedIn at Naptons LLP and Twitter at Naptons Online. Take care, stay safe, and thank you very much for joining us.